Barring the accusation of bribery against the Economic Financial Crimes Commission, the House of Reps Committee has actually invited the head of the EFCC, Ola Olukoyede, including the officers said to be responsible for these allegations and the bribery, of course, involved in the allegation anyway, to appear before the sitting probably very soon in order to answer cases as regards the allegations leveled against them. And at this point, I have a legal practitioner, public affairs analyst, Toho Seriwoja, who will be helping us understand the legal implications of this. Toho, it's nice to have you around. I believe we can hear you now.
Yeah, thank you. You're welcome.
So let's understand the legal angle of this invitation by the House of Representatives investigating the EFCC concerning the bribery allegations. What's your take on the situation so far?
Okay, first of all, I want to say that the House of Reps and the committee, they have the constitutional right by virtue of Section 88, subsection 1, paragraph A of the Constitution to invite the Economic and Financial Crime Commission, the chairman of the Economic and Financial Crime Commission, because the Economic and Financial Crime Commission exists as a result of the act of the National Assembly. So it's part of the constitutional responsibility of the House of Rep to invite them over an issue which they believe is of public concern or that has to dent the image of the commission. But however, I believe the House of Reps are in a rush to carry out the oversight function because the matter is still too early for them to intervene. And I want to commend the EFCC chairman who has taken it upon himself to swing into action immediately such allegation or the tape was discussed on social media.
If you say the Green Chamber is actually in haste to intervene in this matter, what would you have expected in terms of procedure when it comes to investigating cases of bribery like this?
Okay, first of all, the EFCC, the Economic and Financial Crime Commission, has disciplinary measures put in place for area officers. And those disciplinary measures, the first activation the chairman has done is to call for the officers involved in the alleged corrupt act, and also cause investigation, which EFCC within their mechanism, their internal mechanism to deal with erring officers has already they've already activated that mechanism. So first of all, what the House should have done is to wait for the outcome of the EFCC investigation of their officers, because they have disciplinary measures, and the disciplinary measures will be followed to the latter before the House dive into the issue. And I believe that this is not an issue that's meant to be of great importance to the House now, rather than looking at other sensitive areas in the Nigerian economy and policies and politics. So, but I don't really know. But for me, I believe the Office of the Attorney General, which acts as a supervising role, should have been contacted for further details. And also the Ministry of Interior, which is the supervising ministry of these bodies, ought to have also be giving credence as to the procedures put in place for erring officers. Because what the House of Reps is doing now, they may end up compromising or complicating the issue at hand.
Okay, so let's look at the details now. What rights do individuals involved in the investigation have, especially regarding protection against self-incrimination and public disclosure?
No, well, first of all, if you look at the clip in question, you can neither both parties, neither the person who is making the call or the person who received the call, because you could see that from the recording thus far, you discover that it is either of them that disclosed the content of that conversation. So one, the issue of privacy cannot in any way avail Idris in question now, who is popularly known as Bobrisky. Issue of privacy cannot come in. Issue of data protection can never come in that regard. So, but another thing again for the Martins in question, which is popularly known as Very Dark Man, on his own way of making, or his own way of seeing a better society, I think he also have the right to decline the invitation of the House of Reps, because it's not an institution of the is not an institution or is not an institution or an employee of the federal government. Okay. But be that as it may, as issue of respect and courtesy, he can honor that invitation. But I think the proper thing that should be done, is what the EFCC chairman has actually done, and also the Minister of Interior. I think they actually did the proper thing. But I don't know what the House of Reps is coming into for. Okay, so we've seen trending social media conversations and people wading into the matter with different opinions as we speak, and different evidence is coming back and forth as regards to who is right and who is wrong. So I'm wondering what influence this might have on the admission of such a situation as regards the allegation and the eventual outcome of the allegation. Well, if you listen to the tape carefully, you discover that if EFCC will actually carry out their due diligence on some of the conversation, like me, I'm a lawyer, I'm not an investigator. There are so many names that are mentioned, and there are so many specific amounts that were called, and the period in which these amounts left an individual account to another account. So that can be a circumstantial evidence within the ambit of their investigation. And also, we understand that the prosecuting team of the prosecution, which is the EFCC in this regard, first of all, let me question the fact that majority of us, when this issue came up, we knew for sure that by virtue of Section 6, and Section 6, which is the general power of the Economic and Financial Crime Commission, and Section 7, which is the specific power of the Economic and Financial Crime Commission, does not give them the power to prosecute somebody that committed an offense under Section 21 of the Central Bank Act. So that is for one. But under the Money Laundering Act, under the money laundering charges they brought, they have that particular power. But the reason why they withdraw that charge is another circumstantial issue the investigators will look into. Because for a plea bargain to be entered, there are procedures stated by the Administration of Criminal Justice Act 2015, which if you look at Section 270 of the Act, you see that the procedures that the prosecution need to follow for a plea bargain to be taken. So all these are circumstantial evidence that will aid the investigation. Then moving forward, whether those evidence will be admitted in court or not is issue of what the Evidence Act says and how the evidence are collected. And also, we should also overweigh that the court is not a court of public opinion or emotions. The court only work on what is brought before them. And the things that are brought before them, are they admissible in line with the Evidence Act or circumstantial law that will make them admitted? So those are the things. But I believe that it's really sad that these things are coming out in this particular way. Well, then we'll wait for the outcome of the investigation, but on the part of the Green Chamber, that's the House of Reps, and of course the EFCC. Thank you so much to Host Roja for sharing your legal perspective to this. You are welcome.